Hello, my dear friends. Welcome to Hari Shewa IBBI Valuation Cracker. My name is Rajesh S. Wadhwani. I am civil engineer and IBBI registered valuer in land and building asset class. Today we are starting session 5 of laws related to real estate. In session 1, 2, 3, we have learned Transfer of Property Act 1882. Session 4, we have learned land acquisition and silent feature of Real Estate Regulation and Development Act 2016. Today we are starting topics general building rules and regulation, rent control laws, and right of way and section 52, that is Easement Act, license under the Indian Easement Act 1882. So first we will start from the easement, then Rent Control Act, then we will learn general building rules and regulations. Let us start Indian Easement Act 1882. What is the easement? An easement is a right granted to the owner or occupier of one parcel of land to use the land of another for the beneficial enjoyment of their property. It allows the owner of the dominant land to either do something on the servient land or prevent the servient landowner from doing something that affect the dominant land. So I will explain by this diagram. This is a landlocked plot. This other all side is plot is there. Yeah, back side other things say water body is there. Say how to go to this plot. Road is this side. He cannot go from this side. Then he will go to reach his plot by this plot. So two plots is there, parcel A and parcel B. Here parcel A is coming through parcel B plot. He is enjoying to his building rights and plot rights to come from here to this side. So he is called a dominant parcel A, dominant plot. He is servient parcel B. He is providing service and parcel A people is going from this land. Actually, this complete land is belongs from parcel B, but he having no other access or roads, so he has to permit parcel B plot permit to go from this way. This right of way is a easement coming under easement. This complete right of way is coming under easement. My Hindi viewers, it is clear to you also. दो प्लॉट हैं, एक सर्वियंट पार्सल प्लॉट है, एक डोमिनेंट प्लॉट है. इस रास्ते में जाने के लिए डोमिनेंट पार्सल ए के पास कोई रास्ता नहीं है. इधर भी प्लॉट है, इधर भी प्लॉट है, बैक साइड कोई रिवर है या अदर लैंड है, फॉरेस्ट टाइप लैंड है या जंगल है. तो ये बंदे को पार्सल ए के बंदे को अपने प्लॉट अपने घर में जाने के लिए एक रास्ता चाहिए होगा, वो इस रास्ते को यूज करेगा। जो ये रास्ता प्रोवाइड करता है ये दूसरे के प्लॉट के अंदर लैंड आता है, तो इस रास्ते के द्वारा ये जाएगा। तो ये रास्ता जो सर्वियंट पार्सल बी जो इसको रास्ता दे रहा है वो राइट ऑफ वे, वो ईजमेंट के अंदर आता है। सर्वियंट इसका नाम इसलिए रखा है क्योंकि ये सर्विस प्रोवाइड कर रहा है। डोमिनेंट ये आराम से रहेगा, मजे से अपने प्लॉट में रहेगा और इस रास्ते से दूसरे की लैंड के रास्ते से आएगा। इस हिसाब से आप समझिए, याद कीजिए। सर्वियंट प्लॉट मतलब जो सर्विस प्रोवाइड कर रहा है, जो अपना अधिकार दूसरे को अधिकार दे रहा है कि हाँ बेटा तुम मेरी लैंड में से चला जा, वो तो सर्वियंट पार्सल बी हो गया। जो जा रहा है वो डोमिनेंट पार्सल ए हो गया। So many times question is coming, who is the dominant and who is the servient parcel B. So dominant parcel A, this parcel require a right of way over servient parcel B to access the road. This is a dominant parcel. He want the right of way from the servient plot. Servient parcel B, the land that is burdened with the liability of providing access to the dominant parcel, इसके लिए तो ये burden है कि अपने प्लॉट से ये जाने दे रहा है, तो that is the servient parcel B. Key terms of easement: dominant, heritage or tenanment. This word is tenanment. Tenanment means, tenanment is derived from the legal terminology, meaning a piece of land or property that is subject of right of obligation। एक राइट यूज करेगा और दूसरा के ऊपर ऑब्लिगेशन। तो डोमिनियन हेरिटेज टेनेंटमेंट, द लैंड फॉर विच द राइट इज ईजमेंट इज एग्जिस्ट, दैट इज कॉल्ड द डोमिनियन हेरिटेज। आई यू एक्सप्लेन इन पार्सल ए एंड पार्सल बी। सर्विएंट हेरिटेज, द लैंड दैट बियर द बर्डन ऑफ ईजमेंट is called as servient heritage, or other word is dominant owner and servient owner. Who is the owner of the plot? He will call the dominant owner. Who will the owner of servient plot? He will call a servient owner. Characteristic of easement rights: dominant and servient tenements, there must be two separate parcel of land. It is compulsory two parcel land and different ownership, not a same ownership of parcel. If two plot is there, one parcel of A, other parcel to be B. If owner is the same, then this will not called easement rights. Beneficial enjoyment of dominant tenement. The easement must directly benefit the dominant property, as in the case of right of way in the diagram, which provide access to the road for parcel A. Remember that old one figure I shown same. Here on this figure A was the different. Okay, I am making a again figure here. Two parcel. This is the A. This is B. This is the right of way, and this is the road. The road, from road he will come from this direction. Servient heritage that we all learned. This is A, B. This is the easement. Beneficial enjoyment of dominant tenements. Okay. Separate ownership. Dominant and servient tenement must have different owner. Both should be different owner. Specific and defined nature. The easement must involve specific right, such as a right of way or visible in the diagram. Other type of easement is also there. Air easement, sunlight easement, water easement, and for utility easement, electrical wire will go from here to here, that easement. So there different names is there. We will learn one by one. Positive and subject of grant. The easement must be capable of being granted or legally enforced. Positive and negative easement. Easement allow the dominant owner to perform an act on the servient land. Ex- Example, parcel A is right of way cross pass through. Parcel B land is a positive easement. Parcel B land will call a positive easement. What is the negative easement? Negative easement restraint the servant owner for doing something that could affect the dominant land. If servant owner here the right of way, if he want to construct here something, this is called a negative easement. He will stop it. Restraints and servant owner for doing something that could affect the dominant land. Example, restriction of building structure that block air and light to dominant land. One more example I will explain you. In negative easement. Say two plot is there. One is constructed. Two plot A and B. A is a constructed here building. B plot has not given any attention and he has put one window here. So B plot cannot stop his wind. So he can construct his building to leave some space and he can construct his building. In same way, first floor or second floor, this is I will make a section. This is A building, ground floor and first floor. B is having only ground floor. If A window is there, so B cannot construct building and stop his air of A dominant, and this is for negative easement for B. This is called a negative easement to B. He will stop. He will stop to construct this first floor building. This is called a negative easement. Hope it is the clear. Now one more diagram for understanding. Say plot is there, lot 1, lot 2, lot 3, and public road is here. So for lot 1, For lot 1, this easement right of way. This is called easement. And this easement is necessary, otherwise lot 1 plot cannot go in this building backside other buildings and other after that road is there, yeah, water body is there, yeah, forest is there, so he cannot come from the backside. So he has to go lot 1 building by this way only. This is also called a necessity of easement. This is a necessity of the easement. He can go by this way only. Here one lot 3 also. He has seen ki already people are using this easement. People are using this easement. He will make road in this fashion to reach his home. This is called a conventional easement. And which easement is appear? That is called a apparent easement. And which easement is not appear? See here, Shewa line. This is a Shewa line. Here he can put directly Shewa line this, and one main Shewa line, municipality Shewa line is going this way. This Shewa line or a water line, one water line is also going this way, and water line, municipality water line is also going this way. Yeah, after the road also, and he can take this. Water line, sewer line is inside the ground. That will not appear, not visible. That is called a non-apparent easement. Hope this is a clear. Now we go step by step. My Hindi viewers, hope by this figure it is the clear. लॉट 1 में जाने के लिए जो ईजमेंट हो गया वो नेसेसिटी ऑफ ईजमेंट है, इसके पास कोई रास्ता नहीं है। और लॉट 3 को जाने के लिए कन्वेंशनल ईजमेंट हो गया, वो इधर से भी रास्ता बना सकता था। ये कन्वेंशनल ईजमेंट हो गया। जो आपको ईजमेंट नजर आ रहा है विजुअली, दिस इज द ईजमेंट, दैट इज कॉल्ड अपरेंट ईजमेंट। और जो यूटिलिटी लाइंस हैं, जिन यूटिलिटी लाइंस जो नजर नहीं आ रही हैं, ग्राउंड के इनसाइड हैं, दैट इज कॉल्ड नॉन अपेरेंट ईजमेंट। ये जो लॉट 1 की जो लाइंस आ रही हैं, सॉरी, फॉर लॉट 1 की जो भी लाइन है, ये सीवर लाइन है, ये वाटर लाइन है, वो लॉट 2 के द्वारा आ रही है, तो ये नॉन अपेरेंट ईजमेंट कहलाएगा। दिस इज कॉल्ड नॉन अपेरेंट ईजमेंट। ओके, apparent and non-apparent easement, observable and evident rights such as a pathway। आपको गांव में, विलेज में भी कई बार ईजमेंट, गांव के खेत होते हैं 1-1 किलोमीटर, 2-2 किलोमीटर, एक पगडंडी नजर आती है दूसरे के खेत में जाने के लिए, तो वो जो पगडंडी है, जो पाथवे है, दैट इज कॉल्ड ईजमेंट। Example diagram: the pathway across parcel B is a visible and apparent easement. For this figure, lot 1 to lot 2 go, this pathway is visible. That is called a apparent easement. Non-apparent easement, rights that are not visible, like underground pipeline or water drainage. From here to here, underground water line and pipeline is going, or sometime electrical lines also can go. Electrical line, electrical people will put one line this to this way, for this way, and again they will put from here to here one electrical line. So that is called a electrical easement. Continuous and discontinuous easement. Rights enjoy without any human action, like drainage of water or access to light and air, is called a continuous easement. Discontinuous easement require human action to use the easement. Example, the right of way is discontinued because it requires a dominant owner to actively use the pathway. So sometimes discontinue can be done. Easement of necessity and quasi easement. Easement of necessity I already explained. This is the easement of necessity. Here no other way. Lot 1 people go from lot 2 only. And quasi easement exists when a common owner of two parcels enjoy a right over one for the benefit of the other. It becomes an easement when the parcels are sold to different owner. So what is this? If earlier is the owner one, assume earlier is the single plot. So no boundary wall is here. He is using same going and is both the house from here to here. Now he has divided the plot and sold and two different owner. Then lot one owner will get this the easement. This is if only one owner, then it will not call the easement. If a single owner sell to two owners, then it will become a easement rights. That is called a quasi easement. An easement when the parcel are sold to different owner. Easement by prescription arise when a right is enjoyed without interruption for 20 years and 60 years of government. यदि कोई आपकी जमीन को 20 खेत को 20 साल से पगडंडी से जा रहा है तो उसका ईजमेंट पे राइट हो जाता है, दैट इज कॉल्ड ए प्रेस्क्रिप्शन. ईजमेंट पे प्रेस्क्रिप्शन. और यदि गवर्नमेंट लैंड है बीच में, वो 60 ईयर्स से जा रहा है, तो वो राइट्स हो जाते हैं, राइट टू एंजॉय विदाउट इंटरप्शन. If a right of way or parcel B has been used by parcel A owner over 20 years, it become an easement by prescription. Termination of easement. If the region no longer exists, I, how it is terminated in some special condition and it can be terminated. You can understand by the example. This is a two parcel land I earlier explained. This is A, this is B, this is the easement, this is the road. If A parcel vacate this land and sell to B, then no owner is one, and then no easement will be there. If the region for the easement no longer exists, that is the region of termination. Parcel A is no road access to the main road. Parcel B provide a right of way easement to parcel A. Situation, this was the situation. Parcel A is vacated or the property is no longer in use, or he can sell the property to B. So no uh, longer easement will be there. That is called the termination of easement. Or other example, one more. This is the same example I am giving. This is a parcel A. This is a parcel B. Due to government policy, something this backside new road is government prepared. Yeah, made it municipality and other. Now he can go a plot. People can go from the this side. So automatically this easement will be terminated. Parcel A original used the Parcel B land as a pathway for access. A new backside road or right of way is developed for Parcel A. Result: the easement over Parcel B is no longer necessary and may be terminated because the dominant land now has direct access through its own means. Express or implied release. If the dominant owner give up the right voluntarily, if dominant owner does not want to use his that easement, then it is called express or implied release. Expiration of period. Easement granted for a specific period terminate after the duration ends. Servant owner revocation. In some cases, the servant owner may revoke the easement if the right allow, if the rules allow. Here you have seen this lot 3, lot using this easement. So lot 2 can revoke this easement. He can tell he can use from this plot, this land, if law permit. End of necessity. If the necessity for the easement sees such as parcel A gaining direct road access, that is end of necessity. This is the complete easement. One number MCQ is coming. Practice MCQ from dominant and servant. Sometimes so many times definition is coming and type of easement is coming. What is apparent easement, non-apparent easement? This type question is coming. Example of easement. Right of way through a neighbor's land to access the road. Right to draw water from a neighbor's well for household use. In neighbor well is there, if another separate owner using that well and taking the water, that is also called a easement. Right to conduct water through the neighbor's land for irrigation purpose. If backside house water body is there, if it is touching the one plot and he want to use it, that is called another type of easement. Right to receive light and air unobstructed from the servant land. This I explain you. These are the type of easement. Now, second topic is Indian Rent Control Act. Why Rent Control Act is needed? After independence, hundreds, thousand people movement from here to there, thousand in lakhs, and villager peoples also moving in city area. There was a problem of housings. The landowner is asking as per their wish rent. So government decided to bring a rent control act. The Indian Rent Control Act is critical set of regulation governing the rental housing market in India, introduced initially in 1948, shortly after independence, and it was aimed at addressing the severe housing shortage and protecting tenants from expoliation during a period of rapid urbanization and economic recovery. Due to this, Indian Rent Control Act is came. This act is applicability and jurisdiction. State-specific law. Rent and tenancy matter are regulated by State-specific Rent Control Act, reflecting local condition and requirement. The state can change the Rent Control Act according to their state condition, local condition and requirement. Lease duration. If in Rent Control Act, lease duration more than 12 months, then Rent Control Act will be applicable. If lease duration is less than 12 months, then license will be applicable. So Many peoples are now giving their property on rent on 11 months only due to save from the Rent Control Act. Key definition: landlord and tenant, you know it. Scope of the act: certain property are exempted, including these properties are exempted from the Rent Control Act. Central and state government, statutory bodies, property leased by foreign missions or international agency, register lease under the Registration Act 1908 with tenant constant. These are the exemption from the Rent Control Act. Provision of regarding rent: fair rent or standard rent. Sometimes it is called a fair rent, sometimes it's called a standard rents. Many times question will come, uh, what type rent is fixed by the court? So that MCQ answer will be the standard rent, fair rent. Fixed by rent controller, either partially landlord or tenant can approach the rent controller. This rent controller will be decided by the state government, who will give the responsibility. Basis determined by the factors such as market value. How he will determine the rent? He will take the market value of that time, cost of construction, amenities provided as per respective state tendency. Each state having different. Some state giving on the total cost of construction, giving 7% or 8% rate and deciding the fair rent and standard rent. Judicial role: a court may intervene and resolve dispute regarding fair rent and eviction. Rent payment in dispute: Section 11A Tamil Nadu allow rent payment through a court during dispute. If any dispute is there, rent can be paid by through court. Appeal for revision: Section 23 and 25 of Tamil Nadu. Mechanism of reviewing decision or rent or other tenancy matters. Issue in rent fixation: dependency of guidelines value. Court often use a GLV or critical rate, circle rate which may reflect the actual market value. Delayed process: rent fixation based on the petition date. One number MCQ is coming. Which date Rent Control Act will be applicable? It will be from the date of petition, not the date of valuation, not current current property valuation, often leading to outdated rent level. So it is not fixed on the valuation, it is the fix of petition. It will take times and as per petition date market value is taken. Low returns: controlled rent typically yield lower return due to prolonged litigation and fixed rates. This is tenant protected. Earlier in 1948, when this Rent Control Act is made, is a thought it will be protected the tenant and also protect the owner. So actually, it is more tenant protected against eviction. मैं इसको खाली आप नहीं करवा सकते. रेंट कंट्रोल एक्ट में एक बार जो बैठ गया तो फिर खाली नहीं हो सकता. On some typical condition पे कुछ खाली किया जा सकता है. Let us go. A tenant cannot be evicted if they are paid the standard rent. If they are paying the standard rent, you cannot tell to him you vacate the house. Permitted increase within 90 days of notice or summons. And otherwise you have to give 90-day notice or summons with suitable reason. Eviction is permitted only bona fide grounds. Such in this condition, eviction is permitted if he is not non paying the rent on time. Unauthorized subletting, he is again doing other to sublease it, then you can ask him to vacate the house. Property misuse, if he is not using property correctly, illegal, he is doing illegal activity, creating a nuisance, structure deterioration, he is demolishing a structure. So only in this condition is possible to vacate the house, otherwise not at all possible to vacate the house in Rent Control Act. Court ensure compliance with eviction law protecting tenant from unlawful disposition. Valuation implication. Rent control property often have reduced market value due to restriction rental income and tenanted protection. The valuation will come that if a house is given on rented, then you have to do the valuation on income approach. Whatever income is generating, rent is less, then your capitalized value will be the less. Long standing tenant paying outdated rent further lower the investment appeal. Fixation of fair rent. Valuer rely on market rate, guideline rates, and court judgment for fair rent determination. Return on investment for residential purpose, a 9% gross return is common, while non-residential property yield is 12%. Earlier in 1947-48, this was the fixed the total cost of construction and 9% gross return. But after that, it is very difficult to increase the rent. Once rent is fixed, that they will pay continue, or they will increase nominal rate as per court intervention only. Calculation of fair rent. Component include market value of land and portion of apparent vacant land. Cost of construction based on PWD rates. Depreciation calculated using a linear method. Challenges in rent control legislation. Many laws are skewed towards tenant protection, making eviction challenging. Tenants often exploit this law to pay outdated rents irrespective of market rent. So tenant owner will not getting the correct market rent. That is, they are getting outdated rent. Market distortion. Rent freeze discourage property owner and investing in maintenance and development. If a property owner will get less rent, then he will not take interest to maintain the property and redevelopment of the property. Encourage informal agreement, then owner will do 11-month agreement. That is, they will do leave and license arrangement. They will not go for lease. State specific features. We are studying in Tamil Nadu features. Each state having their own rent control act. That some differences is there as per state condition only, side condition. Uh, Fair rent calculation. Residential building 9%. They are in Tamil Nadu 9% the gross return. A non-residential building, 12% gross return. Section 10, 14, 15 of Tamil Nadu substitutional security tenant while defining condition for eviction. Rate specified in Schedule 2 of Act applied using the linear method. Depreciation will be applied accordingly. Conclusion. The Indian Rent Control Act play a significant role in regulating landlord and tenant relationship, ensuring affordability for tenant while balancing landlord interest. However, in tenant-friendly provision often lead to litigation and reduced property returns, directly impacting valuation. A thorough understanding of state-specific rent control act and their valuation implication is essential for land and building value. From this Rent Control Act, one MCQ is coming in exams. Please go through it and see and practice MCQ on Rent Control Act. Simple to get 1 mark. Now next topic is general building rules and regulation. This rules and regulation is infinite, no limit, and syllabus only one line is written. So I am here prepare or not whatever type question is coming in IBBI exams only. Let us go ahead. Building rules and regulation formulated by local municipality or urban development authority are essentially for orderly urban development. These rules ensure safety, aesthetic, and proper utilization of land while addressing environment and infrastructure concerns. Below is a comprehensive overview. Building by law. Building by law are legal tools regulating coverage, that is FSI, height, building, bulk, and architectural design, and ensure plant development. Mandatory nature. This law aim to protect against fire, earthquake, noise, structure failure, and other hazards. They are coming mandatory nature. Silent feature of model building by law, safety and security, structural stability and fire precaution, barrier-free environment, inclusive design for accessibility, environment concern, green building practice, and eco-friendly measure, modern construction technology, adoption of advanced method and material. Swachh Bharat Mission, incorporation of sanitation measures, ease of doing business, simplification of approval process, rainwater harvesting mandatory in many areas, communication technology, provision for infrastructure to support ICT advancement, city development and FSI. This FSI is very important to decide the flats, how many flat he can construct and how many floor he can go it. The FSI ratio determine the total built up area allowed to plot relative size. This already we have study learned in market approach. Please go through the market approach video and see the definition and numerical question we have done on FSI. FSI govern the density and scale of construction in urban area. Master planning and zoning rules, town and country planning. Overseas planning and development in urban and rural area. Master plan are prepared for urban centers and notified rural area through indicative land use plan. This plan regulate residential, industrial, commercial, and recreational and public spaces. Town and town planning organization, town and country planning organization, TCPO. The apex court body for urban and regional planning strategies responsible for monitoring central government scheme and development policy. Zoning rules, part of the development control regulation, ensuring proper allocation and regulation of land use. Now these are regulation for open space, height, distance between building. This every line MCQ came in the IBBI examination. Sometime they can ask minimum open space for residential building, minimum width of 3.6 meter, commercial building, minimum width of 4.5 meter, a maximum open space width 20 meter rounded to the nearest decimeter. Distance between buildings must be minimum of half the height of the tallest building. This all MCQ came in IBBI exam. Height regulation, the size of plot determine the number of dwelling unit allowed, ensuring proper density and open space. Means FSI will decide the number of dwelling units. Group housing and parking. This question also came in many times. Density pattern. Group housing and density is calculated as 4.5% per dwelling unit. 4.5% per dwelling unit. Remember this line. Also, so many times MCQ came parking standard. What is the if open parking? What is the minimum area is required? 18 square meter per car. If cover parking, minimum area is required 23 square meter per car. Basement parking, if there, then minimum area is required 18 mm, square meter per car. Building plan and plinth height. So this question came in IBBI examination. For plot up to 1 hectare, site plan must be drawn to scale 1 is to 500. Building plan must be drawn to scale 1 into 100. Plinth height. No building shall have plinth height less than 55 centimeter from the surrounding ground levels. Exemption is an special permission. Certain operation structure, railway, national highway, major ports, and defense establishment may be exempted from building regulation, ex- except this related to floor space index for fire safety and upon special permission. Okay. And remember this also. Sometime in MCQ he will give, or in case study, 5 acre land, then you have to convert it hectares, then square meter, how it will convert, you remember this. Remember that conversion factors. And today our session is completed. We have learned Easement Act 1882, rent control laws, and general building rules and regulation. Now only last session is balanced, that is session 6. In session 6, we will learn Mohammedan Muslim laws, Hindu Succession Act, Indian Succession Act, will, and do the practice of MCQ. And before leaving this video, please subscribe the channel and hit the notification bell so that you will get the notification. I am coming also second mock-up test in next week. Please be ready for mock-up test. Thank you.